Yeah, that's fine. You could say that my children receive my estate or whatever when I die, or my nieces and nephews, and you can leave that class open so that it could include unborn, people. So that, in 20 years from now, if there's another child or another niece or nephew, that you don't go back and have to make another change to add that name, you can do it that way, yeah. But if the person wants to make the trust themselves, they have to be an adult. So they have to be 18. Okay? Yeah, on my general website, which is on the other side of my that little card that I have for you, the cummingslegal.com, there's sections about estate planning, conservatorships, Medi-Cal planning, estate administration, and it talks a little bit more about that. Okay, whoever told you that is not actually right, okay? First of all, an IRA or 401k that you have is, for the most part, protected from any creditor claims that you may have, so you don't need to worry about those. As far as doing the living trust, it is not a way to avoid creditor issues, okay? It just doesn't do it because you still own the property. The only way that you can avoid these creditor issues is, if that's a concern of yours, is you have to set up irrevocable trusts where you give up control of the property and maybe only have the right to income or something like that. Now, for a lot of people, that's just not worth it. They don't want to give up that kind of control, and that's completely understandable. The best way to deal with creditor claims, or in particular personal injury lawsuits, is to make sure you have a lot of property insurance and auto insurance, and that you have an umbrella policy. Because realistically, most claims will never exceed $100,000. Let's put it this way: if you're going to exceed $1 million or two, you screwed up really bad when you hurt that person. So, despite what you hear on TV and all that type of stuff. So, yeah, it's not a vehicle to avoid creditor claims.
With all the short sales that are going on, what do you recommend for asset protection? If you do have an asset.
Well, again, I mean, there's a couple things that you can do. An irrevocable trust is a vehicle for asset protection, as far as sheltering that particular asset from creditor claims. Anytime you do asset protection, however, you have to do it knowing that there's not a pending claim against you. Okay? If you know you're going to be sued, or you're in the middle of being sued, as an example, and you try to do some of these things for asset protection, that could be considered what's called a fraudulent conveyance. And so that creditor can later try to go after you to undo everything. Okay? But if that's not an issue, again, setting up an irrevocable trust is a way to get some type of asset protection. As far as a short sale, you have to look at if it's well, a short sale is typically not going to be an issue because you've dealt with the creditor ahead of time, and they're going to accept the sale price in lieu of whatever you owed on the loan.
Well, they do on the first. What I've seen, is that they'll do it on the first, but not on the second.
Yeah, and that's just a matter of negotiation. I mean, some lenders are going to do that because if they see that you don't have any money to go after anyway, they'll take what they can get rather than go through the foreclosure process, incur all those expenses that they're never going to get back. Okay? But it's really a matter of negotiating with the lender. But yeah, you are correct. On a first mortgage, then it's what's called a non-recourse loan. That means simply that the lender can't go after you personally. Other properties or second mortgages on the same property, those are typically recourse loans where the lender does reserve the right to go after you personally up to the amount that's owed. But again, kind of the whole definition of a short sale is if you can arrange it, they're going to accept whatever they can get in exchange for not going after you later. And the reason they often will do it, if they do it, is again, it saves them on foreclosure expenses and that type of stuff.
It seems like they're getting real tough on that though right now.
Yeah,
like
and that's,
seconds aren't going to forgive or
yeah, and that actually is
of liability.
Yeah, and that's, to the extent that, we can do irrevocable trusts, we may be able to protect some of the assets. But again, if that situation is presenting itself and, it's known about, that may not work because, again, the lender could always try to go after it as a fraudulent conveyance, if you were to put your personal residence or something into an irrevocable trust. Okay? Just as an aside, I mean, I think it's rather disheartening that, these banks got all this money under TARP, from 2008 on, and they're not being willing to, forgive some of these loans and stuff with frankly, a lot of them they probably shouldn't have made in the first place because of, you know, some of the rules that were in place. But unfortunately, that's just the way the situation is, that the banks are tightening up on doing the, not allowing short sales and that kind of thing. I think it's really short-sighted, but, you know, there's not much that can be done about the bank, you know, the bank if they're refusing to do it. Now, there are people, this is just another aside, that if you have a loan that's been sold a bunch of times, there are people that can actually file what are called quiet title actions against whoever the lender is. Because if the lender can't produce the original note, there is a chance that you can actually have the note extinguished entirely. Now, it's a slight chance, but there are people that have been successful doing that. I know specifically there's a legal aid attorney in Florida that's done that quite a bit. No, I mean, you know, so that may be something that, you know, if you're in that situation, you may want to look at as well. Because it's not uncommon if a loan's been sold 4 or 5 times where the bank has no clue where the original note is. No, I don't know how to do it. I've just read about it. But I know it's been successful.
Do you offer bilingual services too, Mr. Cummings?
I don't, but you know, if I know ahead of time someone's coming in, I do have people that I can have in. For example, that can speak Spanish. If it's beyond that, you know, I can pay, there's actually an interpreter firm in my building, so, I mean, I could literally find probably someone that speaks any language if I needed to. Okay. So the question was if, you know, the parents have died and now there's some kind of dispute amongst the beneficiaries who are the kids of the living trust, you know, what happens in that situation? Well, typically in that situation, you know, one of the kids often is the one that's in charge. And usually the dispute is the children, other children thinking that they've either mismanaged the estate or they're not distributing it fast enough or whatever. If they're all sensible, you know, they'll go to mediation and save a lot of money, but usually that's not the case and they're not sensible. So they all get attorneys and, you know, they fight it out. And ultimately what happens is it typically goes to mediation because the attorneys tell them, hey, look, you know, there's really no point in you spending $100,000 in attorney's fees, you know, to fight over $50,000 of assets or, you know, whatever it is, okay? So often these things do get resolved in mediation, but you may have spent $10,000, $20,000, $30,000 in attorney's fees. Often, in my experience, the biggest disputes aren't necessarily about money, it's about stuff. Okay? I had a client who was a trustee, and you know, she did kind of not do things as quickly as possible. Ultimately, we agreed to have her resign in place of a professional fiduciary. She bought the house that was her mom's, and then we went to mediation over some other outstanding issues, which primarily dealt with stuff. It wasn't about money. And ultimately, we settled it, but it was only after her sisters insisted that they get back a refrigerator and a stove that had been given to Mom 8 years before. And my client just said, hey, that's fine, you know, I'll just get new ones. But I mean, that's what it boiled down to, is they were willing to walk out of this agreement that all of the parties and their attorneys had worked out over an 8-year-old stove and refrigerator. Okay? What often happens is all the resentments that have been building up since the children were kids all come out when Mom and Dad have passed away. And it can get ugly. And again, you know, most of these things could be mediated because they're not very big disputes. You know, now sometimes they can. You know, someone blatantly stole money, but they refuse to admit it or pay it back. Then yeah, you're going to go to court and you're going to spend a lot of money, and ultimately you'll get an order either telling the person they need to pay their money back or saying that they can't. They have to have it taken out of their share, you know, before it gets paid back. But that's often what will happen. Is mediation, you go to court. I'm sorry, is there any fee? What?
Is there any distribution fee that you have to pay?
No, well, no. I mean, the only fee that's assessed on an estate or tax is the estate tax. You know, I mean, there's income taxes, but I mean, that would happen if, no matter what, if there was income being generated. The only fees, if you will, would be as if you retain an attorney or CPA to help with the distribution or preparing tax returns. Okay, so how does the person you've named as trustee get notified?
Yeah.
Okay. Well, I mean, if they're out of the country, I mean, hopefully another family member will contact them and say, hey, you know, you're in charge.